Welcome to The Explainer. Today, we're stepping into a legal system where a lawsuit is anything but simple. This isn't just about two sides fighting it out. It's a world of procedural chess where the fight itself can twist, turn, and bring in a whole new cast of characters.
So let's start with a question. When you think of a lawsuit, you probably imagine a plaintiff versus a defendant, right? But what if a lawsuit isn't just two sides fighting? What if the rulebook let you challenge not just your opponent, but the very rules of the game itself, and even let you swap out the fighters after the match has started?
Well, welcome to the litigation arena. This is exactly what can happen. We're diving into Yemeni procedural law to see how a simple case can transform into a strategic battleground with multiple moving parts. This isn't just about winning or losing, it's about mastering the game.
Okay, Section 1. The first thing we need to wrap our heads around is that filing the lawsuit, that's not the main event. It's really just the opening move in a much bigger, more strategic game.
A lawsuit here is definitely not a straight line. The system has all these built-in tools that allow the parties to challenge, to expand, and to complicate the case. These are strategic moves that can alter the very foundation of the legal dispute.
All right, let's move on. Section 2 is all about the first line of defense, pleas. This is the first and maybe the most fundamental strategic move a party can make. So a plea, or aldefa, is a formal objection from the defendant. But, and this is key, it's not an argument about the facts. It's a direct challenge to the legal legitimacy of the case itself. It's like saying, hold on, this whole case is flawed, and we need to deal with that before we go any further.
And this is where things get really tactical. You've got two kinds of pleas. Public order pleas are so important that the court must stop everything and rule on them separately. The court can even bring them up on its own. Other pleas, they might just get folded into the main case, and you can even lose your right to make them if you wait too long. Knowing the difference is a huge part of the strategy.
This is what makes those public order pleas so incredibly powerful. They are so fundamental that they can be brought up at any point in the process. I mean, any point, even if the case has already gone all the way to the Supreme Court. It's a powerful check on the system, making sure core legal principles are always respected. And look at what they can target. You can challenge the court's authority, saying it has no jurisdiction. You can challenge the case itself, arguing it's already been decided. You can even challenge whether the parties are legally allowed to be in court. And the ultimate move? Challenging the very law being used as unconstitutional. That's a game changer.
So when a valid public order plea comes up, the effect is immediate. First, the main lawsuit gets put on hold. Total freeze. Second, the court has to rule on that plea all by itself. And third, it issues a completely separate judgment on it. The main case can only continue if that plea gets shot down.
Okay, so you can challenge the case. But what if you need to change the players on the field? That brings us to our next section, summoning new parties into the fight through a process called joinder.
And there are two main ways new people can get pulled in. A litigant, one of the existing parties, can do it for a strategic advantage, to bring in someone they think is essential to the case. But the court can also do it all on its own, if it decides it's necessary for the interest of justice or, just to get to the bottom of what really happened. All right, Section 4. The arena can get even more complex. The original parties can start adding new claims, and outsiders can literally decide to jump right into the fight.
So the plaintiff, the one who started it all, isn't stuck with their opening move. They can adapt. They can modify their original request, add claims that are connected to it, or even change their whole reason for being in court. They can also ask the court for a quick protective measure if needed. And the defendant isn't just playing defense. They can go on the attack. They can sue for damages caused by the lawsuit itself. They can launch a counterclaim that could completely wipe out the plaintiff's case. They can even ask the court to settle up other debts they have with the plaintiff. All of a sudden, it's a battle on multiple fronts.
And then there's this, intervention. This is where an outsider, someone with a real stake in the outcome, basically knocks on the courtroom door and says, hey, I need in. They aren't summoned, they jump into the arena themselves to protect their own interests.
So let's take a breath. We've got pleas, new parties, extra claims, interventions. The simple lawsuit we started with is now this huge, complex beast.
So how does the court manage all this chaos to actually reach a final rule?
Well, the main goal here is all about efficiency and consistency. The whole system is designed to handle all these interconnected issues in one go. The last thing anyone wants is 5 different trials on related topics, which could lead to 5 contradictory results. It's all about getting one single clear answer.
And this is the bottom line. The court's job is to bundle everything up, the original claim, the counterclaims, all of it, and rule on it together with the original lawsuit whenever it can. The goal is one single, comprehensive judgment that resolves every piece of the expanded conflict at once. It's how order is brought to the chaos. Which leaves us with a final big question. Does this intricate legal dance actually help serve justice by making sure every angle is covered? Or does it just create a complicated obstacle course that makes justice harder and slower to find? It's a fascinating thing to think about.